A very warm welcome. You are just in time to catch us here on 3T TV, Thika's #1 online news channel, where as always, we are telling the Thika story as it is. My name is Juliet Modhoni, and today I am in the company of a learned friend who is going to expound to us on matters succession. I'm an avid reader of the Business Daily, and in January 24th, 2022, there was a report that was published claiming that the unclaimed financial assets has 54.8 billion shillings in financial assets in terms of cash, shares and dividends that haven't been claimed. This means that we as Kenyans are not taking succession seriously. And today we want to talk to somebody who is going to demystify it for us and help us understand. We hope that by the end of this session, you will have learned a thing or two. And if you haven't subscribed, we will give you a good reason to. So let the segment begin. How are you doing?
Fine, thank you.
Thank you so much for having us here again. For the sake of somebody who is watching for the first time, kindly introduce yourself and tell us what you do.
My name is Mwenda Njagi Advocate. I practice in the name and style of Mwenda Njagi and Company Advocates. I'm based at Seattle City Mall, Kiambu Road, Runda, Block A, third floor. Thank you.
Thank you very much. We had a very good discussion last time on tenants and landlords. And today I'd like us to talk about succession. We as Africans view it as a superstition to predict that you may not be there, you may die. But I'd like you to tell us the importance of that. Kindly tell us what is meant by succession in law.
Thank you very much, Juliet. Succession basically is how the law enables you in your sojourn here on earth, how do you wish to bequeath or transfer your property when you're long gone. Simply means when somebody during their lifetime, they acquire two things in here on earth. They can acquire assets and liabilities. And when you go or when you become indisposed, which means you're sick, then maybe you may succumb and die. So the law now gives you an opportunity on how you wish your assets, which you call now the estate, on how you wish it to bequeath to your loved ones, or which we simply call in law beneficiaries. So succession in simple terms is the transfer of property from a deceased person to a beneficiary or somebody who's going to inherit. It's basically a conveyance or a transfer of assets from one who is not there to one who is living.
And I believe there's a document that is usually written. What do we call that document, and what is the importance of having it?
Thank you very much for that particular question. Maybe I should start by saying how somebody dies. Because in law you can die in two ways. Okay. You can die with a will, which we call testate succession, meaning you died having a valid will. You could also die with a will, but the court pronounces it that will is invalid. And I'll give you the test and the ingredients that what could invalidate or could vitiate a will. Or you could also die without having written any will, which we call intestate succession. Maybe for the purposes of our listener, when you have a will, it means the wishes of the testator have been reduced into writing. And the test applicable is that particular testator has to have like the sane mind, meaning by the time you are bequeathing or transferring this property, you are of the right frame of mind, meaning you're not suffering from mental sickness. Secondly, you must have done it voluntarily. Simply means that I bequeathed property A to my child X, and I knew what I was transferring. You did not mistake, or you thought maybe I'm transferring a property Y, whereas maybe you wanted to transfer property Z, meaning you are conscious of your actions and they were willful. The other thing is that there should be no duress or undue influence, because we've had instances whereby families have wrangles and maybe the child can abduct even the father, or the mother have all these assets, and they tell them, look, execute for me this will or sign for me this document, else I'm not going to give you food. And maybe they even put the other siblings out of reach of the other parent. So the parent may sign or execute such a will, but it is not voluntary. The fourth test that's applicable for a valid will is that the testator, meaning the person executing that will, provides for the beneficiaries. And maybe to the listener, because you have had instances whereby you hear somebody says, because you disobeyed me, I'm not going to leave you anything, meaning you're disinheriting them. That's a ground for vitiating a will and setting it aside. Even if you don't like your child, or somebody could call as a beneficiary, and maybe I'll give you classes of a beneficiary, at least provide for them something. That means when you are distributing your assets, you don't have to provide for your beneficiaries equally. It doesn't mean that because you own maybe 100,000 and you have 5 children, everybody should get 20,000. No. All that the law provides, you should give a recognition. If you like testate and maybe your asset base is 100,000, and maybe child or firstborn, that's for purpose of illustration, let's call him child X. He was a drunkard and never took care of you. At least give him 2,000. But you cannot leave somebody exclusively. So when you leave a beneficiary out of a will, that beneficiary can go and say, look, I've not been provided for. But it does not mean that you provide for them equally. So to the listener, even if there is somebody you don't like, but they're your beneficiary, provide for them something to make that will valid. The other one is intestate succession, and that's where most of our people subscribe to. They don't write wills, and so they die without a will. So when you die without a will, the law of intestacy takes in, and maybe if you may allow, I can tell maybe to the listener how the intestate goes about. It simply means that you have died without a will, or the will you wrote, one of person goes to court and says, look, yes, this person wrote a will, but I also have another will. So that now you have 2 competing wills. We have had instances like that, whereby a prominent man was abducted, taken to South Africa, signed there. There's another will which was done in the UK when he was, and one will was leaving some beneficiaries, another will was providing for others, and those issues that arose, which will should take precedence. So in such a scenario, the court may revoke both wills and say this person died as an intestate. The other one now is whereby it happens to the effect that you also died without a will and without writing anything. So that now, if you die such like that, there is a procedure which is involved, and maybe later on, maybe we'll discuss how you go about both scenarios and the procedures for both, because there are different scenarios for either.
Okay. So to be on the safe side, I should indicate all my children so that we don't have a wrangle.
What you should do is that the law provides for a beneficiary, and the beneficiary, there are classes.
Okay.
One of them is a wife, a former wife, even if you divorced.
Okay.
There are children that you bore. There are children who you took like your own and you provided for them and you recognize them. For example, you maybe marry somebody who had a child and maybe you took that child as your own. So you cannot now leave them behind when you're writing your will, and whereas for purposes of the will, you had actually provided for them. You had taken them as your own. The other person is whereby you hear like somebody, you have this prominent politician saying, amekuwa mtoto wangu, like adapting.
Yes.
So what it means that because now you've taken them like your child, and by your conduct, you're providing for them, they can be treated as a beneficiary. But those people that I've mentioned there are some that you may be providing for them. Maybe you say, the way I've seen this child, I'll pay for them school fees. They don't become a beneficiary who will come now and demand maybe land. All that will happen there is because your intention was to pay school fees for them.
Yes.
The estate, if you die, should leave a fraction for purposes of education of the person who you had taken, maybe for purposes of support, because that is the test that is applicable. Is it a child you have taken, like a biological child, who is now entitled for actual inheritance, or is it somebody you had just taken for support? The other thing is that when I say a former wife, does not mean that you have now to provide for them and you divorce them. It's just a recognition. It can even be 100,000 or 50 shillings, because it shows that maybe she also played part in accumulation of the estate. The wife now becomes a first class beneficiary by virtue that you have lived with her and you've accumulated some wealth to them. And also to the boy child, I should also say also the husband also, because nowadays we have women who are equally in meaningful employment and gainful living. The other one now, it goes to second class beneficiaries, who now include your parents. It goes all the way to uncles and aunties to that class. So in simple language, what I'm trying to say, if somebody is your beneficiary, to make that will valid, at least recognize them by give them a share of your estate. And also list your liabilities, because you may be having some loans, you may be having debtors and creditors. Say maybe the fraction of this much will be utilized for purposes of paying my debts. Then whatever is available now is what is available for distribution. So that now it gives a validity of that will. There's also those who cannot die without a will. And maybe when we get there, we'll discuss how it happens and what it entails.
Now, you've mentioned a will. What is the importance of a will? What is a will in simple terms, and what is the importance of having one?
If our people knew the importance of the will, they would stop being superstitious, because some of us have been cultured in the sense that when you write a will, you go to the next world very soon. But the will, what simply means, is that it gives you the power to distribute your wealth when you are 6 feet under. Simply that, because it now gives you the capacity to control your asset. Because usually when you die without a will, it is not the beneficiaries who are left who distribute that particular estate. But when you reduce your wishes into writing, and some of the tests, maybe I should say, it should also be signed by a witness. But that witness, Juliet, they do not need to know the contents of the will. They only need to say, look, on the 28th day of January 2022, I saw Juliet putting pen to paper, and she signed this part, and these were her wishes. They do not need to know the contents. But that particular witness should not be a beneficiary or not getting an interest of that will because of conflict of interest. Because now if you're also signing and you're becoming a witness and you're being mentioned in that will as a beneficiary, the question of validity and the test applicable and whether it was a free will would arise. So that now that witness should be unaligned. Then you now appoint in that will what you call an administrator or an executionist, the person who is going to execute it when you are gone. What that means, they wear now the shoes of the deceased, because you're no longer there. They're the ones now who come in and now effect that will and go to court and seek for something called grant of probate. When they get grant of probate, then they are given the power now to act like the deceased would act. Maybe in the same breath, if you die now without a will, or the will is found invalid, which now becomes an intestate succession, the first thing is that you go to the chief. The other one need not go to the chief because the document is there. The chief says, I know Mr. X, he lives in my location, and I know him. At the point of his death, he is survived by this wife, or these wives, and this child, or these children. Letter of recognition. Thereafter, you attach the death certificate to show that actually the person has passed on. Thereafter, you now prepare what you call letters of administration, which you prepare now, and you list the assets of the deceased and the liabilities.
So this is at the discretion of the chief, or who is listing that?
The person who lists it is the person now approaching the court, asking, because you see the first one we had discussed, one with the will, because the will already, the person had already written. But now there is one who has died without a will. So maybe that's why now if you didn't do the will, then you leave that burden to the beneficiaries to do it.
Sure. Actually, that was actually my next question. If, let's say, a minor, the parents die without leaving out. Now, what happens if in the case that no will was left?
Thank you so much for that question. Let's treat that particular succession like an intestate, because when you say no will was left, it is basically intestate succession. So there are some ingredients that have to be satisfied. One is that we first of all the child, because a child is somebody below the age of 18. Now we look at who is the next of kin, or what we call in law next of friend. And the mother and the father, they are also succumbed to the accident. So we leave now to the uncles or well-wishers or parents. So those are the people now who should now go to the chief.
Okay.
The same way, and say, I know Mr. X and Mr. Y, they were in my jurisdiction, they were man and wife, and both have died. At the point of their death, they are survived by these children who also died in the accident. But these two minors have survived. So they become the beneficiaries of the estate. So on the strength of that letter from the chief now, an auntie or an uncle can now file a suit on their behalf, on behalf of the children, and say, look, I have a letter from the chief, I have the death certificate, the parents of these minors died without any will, but he had a pension, and there are some funds that are in the account, and he has some properties which can help these children. So the court tells you, after you file, you can wait for 6 months, and it has to go to Kenya Gazette. And this applies whether in an intestate succession. The rationale of the 6 months is to grant somebody an opportunity who has a claim on that estate to come on. And then maybe you can come and say, before now it's confirmed, and say, you are trying to confirm the grant to Mr. Y, but you have left me out. I'm also a child of that mzee, or that deceased person. Or I'm also a wife, and you've left me. So now the court now won't confirm. That's why it's giving you the 6 months window period. But if maybe there is somebody who is in need of immediate funds, say there's a child who is going to school, they need school fees, or there's somebody who maybe is indisposed and needs some medical attention, so that it beats purpose for you to wait for 6 months, you can ask for a limited grant. And you tell the court, yes, we will wait for the confirmation of grant through the normal process for 6 months, but Your Honor, or Your Lordship, can you please give me a limited grant for me to access some 50,000 in Bank Y so that I can pay school fees for this child? It's limited for purpose. So if the court is satisfied, and maybe you have attached the school fees, or maybe the medical reports, if somebody is in hospital, it enables you now to access those funds. Okay. If there is no urgency, you have to wait for 6 months, then you go back to court, and then the grant is confirmed, which now gives you the power to transfer the estate. Okay. And in this case, because they are minors, maybe powers of the children, yes, now they may be appointed as administrators, as trustees. They're going to hold the property on trust for the children until they attain the age of majority, which is the age of 18.
Wow. Quite a lot to digest. There's also another issue. In case somebody dies, and they had several bank accounts, and it was probably not indicated anywhere. They didn't have a will. What happens to those bank accounts?
Excellent question, because also, some may be having bank accounts and not disclosing.
Yes, that is the other thing. That is actually the elephant in the room. They never disclose.
So we could treat the bank accounts as part of the estate of the deceased, because an estate includes real estate, which is land and property. It could also include cash at hand and cash in bank, and those kind of assets, or even jewelry, or even cars, or anything that can be bequeathed. So at the point of listing the assets, when you're now filing intestate succession, you should list all the assets. And most likely, you list what you know. So these accounts should also be listed. You should not leave anything, because if you leave anything and the grant is confirmed, you'll have to go to court later to amend, which now asks for more cost. So these assets which you've listed now for the bank account should be listed. And now when you get that grant, on the strength of that grant, you approach now the bank and tell them, look, my mzee died, but I'm the one who is the administrator. And they'll tell you maybe who is an administrator, or I'm the one who was beneficiary of this account. Can you not transfer these funds to me? So the money in the bank account can be treated just like any other asset. And it should not be used or utilized without a confirmation of grant. And maybe to the listener, Juliet, what I need to mention, we have this kind of cultures where somebody has died, and maybe the brother comes and says, this TV is very nice, let me take it. Another one comes and takes the stool. Another one comes and takes a vehicle without even following the law. What they don't know, it's a criminal offense. It is called intermeddling. You should not touch the estate or the items of a deceased person without authority from the court. What should happen? Status quo should remain. You go and present your application to court, and if the court is satisfied, then now it gives you the grant, which now gives you the power to distribute the estate. But you cannot distribute without authority from the court, because it should be a court-supervised distribution.
That is music to the ears of very many Kenyans. It never happens.
You cannot sit down and agree this one is mine. No. It should not be that way. To avoid mischief,
Yes.
because there may be a beneficiary who may be left for America,
Yes.
and you're trying to oust him, he doesn't know. So that's why the court says, approach us, go to Kenya Gazette, because it's presumed everybody reads Kenya Gazette, or you can do an online search, and because maybe you may know your father died, or somebody who you have an interest in died, or even maybe somebody who had bought land from. You could have bought land from this person the family doesn't know,
Yes.
and you cannot finish the transfer.
Sure.
But you know you had paid, and he was at the verge of signing the transfer documents. But the family leased that property as part of the estate. But that property is not available for distribution,
Yes.
because at the point of death, it had already been sold. So that's why it's saying, wait for 6 months, so that if there's anybody with a claim, let them come, to avoid the mischief of having a domestic arrangement.
I think you've answered the other question I had, because it was when a will has been left, what is the time frame that is given by law? When can you start transferring ownership? I think you've answered that correctly. That is 6 months. So within 6 months.
That one was for the intestate one, where there is no will.
Okay.
But now if there is a will, and the will has been found valid,
Yes.
and you've gone to court,
Yes.
it's got reasonable time. And if the court is satisfied that actually you put the Kenya Gazette, there's nobody coming in place to object that will, and you are satisfied, then that will is adopted as a probate or grant of probate, and the estate will be distributed as such, because it is basically following the wishes of the testator. That is the law.
That is within now how many days when there is a will?
When there's a will, it applies the same way, because it has to go for Kenya Gazette.
Or Kenya Gazette. And how long does it take when it goes to Kenya Gazette?
Same period.
Okay. 6 months as well. Okay.
Because it is presumed that is sufficient time,
Yes.
unless the exceptional circumstances, whereby now you can argue that maybe there is immediate relief you want, like school fees, so that you can get a limited access.
No, it makes a lot of sense, by the way. Now, on the other hand, there's a will that has been left, and probably I was given a car, my brother was given a house, and he feels, I probably don't need a car, I need the house, and vice versa. Can we alter the will such that now I bequeath him the car? And is that possible, to alter a will?
Yeah, it's possible to change the property, but not alter the will, and I'll explain you why.
Please do.
Because the will, if it's found valid, we must follow the wishes of the testator to the letter. He wished the property to be yours. He wished the car to be his.
Okay.
But you are more comfortable with the opposite.
Yes.
So what could happen in this arrangement? The grant can be confirmed as it is. Then now, at the point of distribution, because you have an administrator or the executor of the will, you do something called a consent. Because a consent is basically an agreement. It's basically what we call the meeting of the minds. You have agreed, but the grant has been confirmed. You tell the administrator, look, at the point of transfer, because its properties also have to be transferred. Like in land, there are some titles which may be there, and the transfer form. So, at the point of transfer, 4 things are required. 1, you require the original title. 2, you require the transfer forms. But remember, the person who's on the title is dead. So who will sign the transfer? It is the administrator.
Yes.
Which passport, which PIN, which ID will we use? For the administrator.
Allow me to cut you short. Who is an administrator?
Oh, thank you. That's a good question. When person now has died intestate, and you filed to court asking for distribution of the estate, you appoint, as a family, you appoint somebody to wear the shoes of the deceased, who can be the first brother or the mother, who is now administrator. But an administrator He is not like the authority to distribute the properties at will. He is just a custodian, because all of you cannot be signing transfer forms. So like after the letters are confirmed, we'll be using his ID or her ID to transfer to the beneficiaries. Because at the point of distribution, you could say property X will go to this child, property B will go to this boy, you list them. So that when the grant is coming out, you already know who is getting what.
Yes.
So the work of the administrator now is the one to sign the transfer forms. And there's some forms we call RL7 and RL14, transfer through transmission, because he's the one now wearing the shoes of the deceased. So that's the work of the administrator. And also to give an account of the estate. Maybe, Juliet, there may be some properties which are generating rent. All of you as beneficiaries or children of the deceased cannot be going to the tenants. So the administrator is the one who collects the rent and accounts for it, or income generating assets. So that's the beauty of our law, because it wants continuity, and that is the work of the administrator. If you had a will, you have now the one who is called the executor of that will. It's basically the same way, because I say when I die, I want these properties to go to this child and to this child. And because I'll not be here, I appoint you to execute my will. Sure. So in this instance, because you never executed, is the beneficiaries now to sit amongst themselves. It can be one, it can be two or three. It can be a singular administrator, it can be two. You could appoint the mother and the first son. Why it's a big family, you could even have 4 administrators. If maybe them say had four wives, you could have an administrator from each home, or from each household, or from each unit, so that every house feel covered. So it's basically a question of checks and balances to ensure that the transmission happens smoothly and he's able to transfer the assets.
You were explaining something in terms of altering the will, and you said you changed the will instead. I don't know whether you had exhausted on that.
Yeah, what I meant by that particular statement was to the effect that this child wants a vehicle, you want the house. Yes. So you could confirm the will as it is, but at the point of now being transferred the vehicle, you record a consent, and you give authority to the administrator, but it should be captured in the letters of administration. You say, this is my property, but instead of us incurring stamp duty twice, you transfer to me, I transfer to my brother. Can you transfer directly? Then you give your consent. Then this other one transfers to you, because there should also be freedom of the beneficiaries. But first of all, it can only be confirmed as per the wishes of the person. Then when you receive it, not because it's yours, and there is no encumbrance. I'm told some people bequeath property, but you're told never to sell or never to subdivide. But if it is free property, yes, so you can do it as you please. You can subdivide it. You can go to the bank and charge it. You could also transfer at a profit or at exchange. That's what I meant. But it must first of all follow the wishes of the deceased person. So when it's now in your hands, you can now do as you wish or as you please. Awesome. When now the will is opened, because it should be opened in the presence of the beneficiaries, by the person holding it, when the person has been interred, and then reads the contents of the will, it has to go for the issues to do with the gazettement, as I told you, for anybody now to bring an issue on why that will should not be adapted as the issues of the testator, or if there is anybody who is contesting that will. For example, you could have a scenario whereby there is 2 wives, wife A and B. Wife B is the one living with Mzee. He connives and writes, he connives and prepares a will at the exclusion of A. That one is an outright cancellation, because the Mzee did not do it willfully. Because we had said before, it should be a willful distribution. But now you see in B, he's one who is living with Mzee, and maybe he treats him so well to forget A, or does things to make sure that A gets nothing. But the issue to do with transfer was not willful, or maybe was coercion, or maybe he signed something not knowing what he's signing. That's a ground. In terms of the first scenario, whereby you are actively involved in killing or in making sure the person dies for you to inherit, during this intervening period, if evidence is produced or there is reasonable suspicion that actually you did such kind of criminal actions for you to benefit, it leads to a revocation of the will. Because you cannot trigger somebody's demise for you to enjoy the fruits of that will. So you should not be involved or actively involved in illegal actions for you to benefit from a will. And if it is shown that actually you knew, it could also be voluntary. The Mzee had written the will voluntarily, he had bequeathed you so much, but because of your greed and your impatience, you think, how can we enjoy these fruits faster, and you engage in those kind of actions, and then you want to rush to court to enjoy the fruits. The court and the law is very clear. He who comes to court, who comes to equity, must come with clean hands. Your hands are soiled with blood, and you cannot benefit from such kind of an action, because the court, by doing that, would be rewarding an illegality, which it cannot.
Quite a lot to digest. Now, as we come to the close of this session, I'm sure there's somebody who is watching who's probably doesn't know how they could go about this succession issue. You could please give a phone number through which they can reach you, and if you have a final word to advise people on how to go about this succession, it would be good. Yes.
Thank you so much for that question. My closing remarks is that in our sojourn on earth, or in our journey here on earth, everybody's trying to amass something, but we don't prepare and plan for the next phase. So it's always good, as you acquire property, you think on how you wish to transfer them when you're long gone. And I'm always asked, when should you write a will? Is it when you're in your deathbed? What stage? And my answer has always been, as soon as you have your first asset, because first asset, even a single asset, is transferable. And also what I would wish to say to the families, because most of our people are having wrangles in terms of distribution of the estate, I would like to encourage them to consider mediation, because some of these matters, even if they go to court, they can take a very long time, so that by the time the properties are being bequeathed to you, they won't help you as much as they could have helped you before. We have cases whereby cases have stayed even many years, 40 years. I handled one, several years in court, so that by the time you're representing that client, they're in their 70s. They tell you they started the case when they were in their 30s, which they could have helped him much more. Mediation works. Try to sit as a family and agree, because the earlier you agree, the better you're able to distribute the property and also assist you. Lastly, and most importantly, to the breadwinners of the family, have a full disclosure, because we have instances whereby properties are being left in the hands of government because the owners do not disclose those assets to their families and their beneficiary, which end up going to unclaimed assets, because it also helps the people that are trying to work and accumulate wealth to enjoy when you're long gone. My number is 0718 810 300. Thank you.
Thank you very much for your time.
Thank you.
Ladies and gentlemen, you heard it. It is important to write a will. We hope that you have learned a thing or two from this segment. My name is Juliet Modoni. Until next time, take care.